David Hearn's charges are now moving toward dismissal after the Justice Department acknowledged that the damage blamed on the three-time Olympian was linked to a flawed installation at the Lincoln Memorial reflecting pool. Prosecutors filed a motion on July 31st asking a Washington, D.C. judge to dismiss the felony indictment without prejudice. But the most important question is not simply whether the case is ending. It is why information capable of changing the prosecution's entire theory apparently reached federal prosecutors only after Hearn had already been indicted. For verified entertainment updates without the rumors, subscribe to Startline Entertainment. The newest confirmed development comes from the government's own 20-page filing. The U.S. Attorney's Office for the District of Columbia said documents received from the Department of the Interior indicated that the reflecting pool's widespread peeling was connected to a rushed and defective installation by Atlantic Industrial Coatings. Prosecutors wrote that the new information made it difficult to attribute the damage to vandalism, much less prove that conclusion beyond a reasonable doubt. That represents a major change from the government's position at the beginning of July. On July 2nd, the Justice Department announced that a grand jury had indicted Hearn on one felony count of destruction of property. The official announcement alleged that he had ripped a section of newly installed blue sealant from the pool during a June 19th incident. The department also emphasized at the time that the allegation had not been proven and that Hearn remained presumed innocent. Hearn pleaded not guilty at his July 9th arraignment. Before the indictment, he had publicly described a much different version of what happened. Hearn said he stopped at the reflecting pool during a bicycle ride after noticing reports of algae and peeling coating. According to his account, he reached into the water and handled the loose edge of material that was already partially detached. He denied ripping, removing, or damaging it. Hearn also said he stopped touching the material when a National Park Service employee instructed him to do so. The government's later motion does not say that Hearn never touched or pulled on the coating. In fact, the filing describes him pulling on a section of lining. The significant change is that prosecutors no longer believe the broader condition of the pool can reliably be blamed on vandalism or linked to Hearn beyond a reasonable doubt. That distinction matters because the original charge depended not only on proving contact with the coating, but on proving intentional property destruction and damage, meeting the felony threshold. Hearn is 67 and represented the United States in canoe slalom at the 1992, 1996, and 2000 Summer Olympics. His best Olympic result was 9th place in the men's C1 slalom event at the 1996 Atlanta Games. That athletic background is why a dispute involving a piece of loose pool coating quickly became a nationally watched case. But according to the new filing, warning signs involving the renovation existed before Hearn's June 19th encounter with the pool. Prosecutors cited a June 11th email from a National Park Service engineer discussing peeling and contractor overspray. That communication came 8 days before Hearn's arrest. The filing also says installation problems appeared almost immediately after the work was completed. The timeline then took another turn after the indictment. On July 17th, U.S. Attorney Jeanine Pirro and other officials visited the reflecting pool after it had been drained. According to the motion, they saw extensive damage across the pool and requested all available Interior Department records concerning the lining and its installation. Prosecutors said they subsequently received approximately 695 megabytes of additional material that required several days to review. Those documents, prosecutors said, described repeated installation failures and extensive peeling throughout the pool. The filing alleges that work was affected by rain, wind, failed expansion joint tests, and delays in obtaining sealing products. It says the effort to complete the renovation before events connected to America's 250th anniversary resulted in rushed work that had not been fully corrected when the construction fencing was removed. A contractor inspection conducted on July 20th reportedly found overspray and failures in the coating's ability to bond to the underlying surface. The filing says damage was present throughout the pool rather than only along the perimeter, where members of the public could easily reach it. Prosecutors argued that peeling in the middle of the pool was difficult to reconcile with a theory that visitors were responsible for all of the deterioration. That evidence changed the legal calculation. The government said the Interior Department had provided incomplete information at the beginning of the case. Prosecutors went further, stating that they would not have sought the grand jury indictment had the relevant information been provided earlier. The filing also says the delayed disclosure interfered with the prosecution's responsibility to provide potentially favorable evidence to the defense. Those are the government's allegations about the information flow between agencies. The filing does not establish why the material was not provided sooner or prove that anyone intentionally concealed it. Days before the Justice Department changed course, Hearn's attorneys had questioned the grand jury process and requested access to additional testimony and legal instructions. The defense pointed to testimony suggesting the pool was leaking heavily, that its expansion joints needed work, and that damaged lining existed independently of Hearn's alleged conduct. At that stage, Hearn was still scheduled to face trial in September. The July 31st filing effectively overtook that dispute. Prosecutors concluded that the newly obtained material significantly undermined the evidence supporting the indictment. The motion therefore asks the court to dismiss the case without prejudice under the applicable criminal procedure rule. That legal phrase requires careful explanation. A dismissal without prejudice would end the current indictment while leaving open the theoretical ability to bring a future case. It is not the same as an acquittal after trial, and it is not the same as a dismissal with prejudice that would ordinarily prevent the same charge from being refiled. Still, the language in the government's motion is unusually direct. Prosecutors say the evidence now makes it difficult to attribute the widespread damage to vandalism or prove that conclusion beyond a reasonable doubt. There is also a procedural detail that should not be lost in the headlines. The primary court document reviewed for this update is a government motion asking for dismissal. Its final page contains a proposed order stating that the indictment would be dismissed without prejudice, but the copy available publicly does not show the judge's signature. Several major news organizations are describing the case as dropped, but the most precise wording based on that document alone is that prosecutors have moved to dismiss it. Hearn's lawyers responded by saying the case should never have been brought. They characterized the prosecution as an abuse of government power and called for an apology. That is the defense team's position, not a judicial finding. No court ruling in the reviewed material declares that prosecutors acted unlawfully or that any government official deliberately misled the grand jury. The contractor named in the filing is Atlantic Industrial Coatings. Prosecutors attribute overspray, bonding failures, and other installation problems to the company's work based on Interior Department and contractor records. But the motion is not a civil judgment against the contractor, and it should not be presented as a final legal determination of financial liability or misconduct. It explains why prosecutors no longer believe they can sustain the criminal case against Hearn. The broader significance is the sequence. Hearn was arrested on June 19th. A felony indictment followed on July 2nd. He pleaded not guilty on July 9th. Prosecutors visited the drained pool on July 17th, reviewed newly obtained records, and by July 31st were asking to end the prosecution. The case did not change because of a new confession or a new eyewitness. It changed because the physical condition of the pool and the project records challenged the original explanation for the damage. Here is the start line takeaway. The key development is not merely that prosecutors reversed course. It is that their own filing now says information available after the indictment would have changed the decision to seek that indictment in the first place. Viewers should not assume that this equals a court finding of misconduct, an acquittal after trial, or a permanent legal bar against any future case. What is supported by the public record is that the Justice Department no longer believes the existing evidence can establish the vandalism theory beyond a reasonable doubt. As of the latest material reviewed, the clearest status is that the government has requested dismissal without prejudice, and news organizations are reporting the prosecution as being dropped. What remains to be confirmed is the formal docket entry showing whether Judge Todd Edelman has signed and entered the dismissal order. Until that appears, move to dismiss is the most exact description. And that final court action is now the last open point in a case that began with an Olympian reaching into a national landmark and ended with prosecutors examining the renovation itself.